for laws 11062. This is contract B, and this week we're into week 3. Just a note in relation to the tutorial questions, looking at Moodle now, I provided a response on Sunday, and as I expected, as I feared, that seems to have shut down all discussion. So when it comes to the weekly tutorial problems, what I'll ask is that you be kind enough to provide a response on Moodle and upload your answer as if you're answering a question for an examination. Please feel free to respond to others' answers. And obviously people will be very polite, but when you receive a response from a fellow student or from me, and it's not as you'd expected, try to learn from that. So in other words, every time you provide a response, you can assume it won't always be right. There will be times where you get it wrong, or you miss the point, or your emphasis is incorrect. So if someone says, hey, how about this aspect? You don't have to, even me, you don't have to accept what is being said, but it's always a good idea to take it on board. So thank you, Prim, for being the one person I think that provided a response to Samara. So I thought that was very good. The others who provided responses for the first question in week 1, thank you for doing so. I'll delay my response, my thoughts from time to time, but what I said is when I provide a response, it does tend to stifle the discussion. We don't want that. And if you think I'm wrong, please feel free to challenge it. So I'm not always right, and lecturers aren't always right. That's the way it is. All right, so last week we were discussing the fundamental difference between affirmation of a contract and rescission of a contract. We understand the distinction between the two. Do we understand the distinction between rescission and termination? They're very different. So firstly, is rescission an equitable remedy or a common law remedy? We'll go yes, because I answered a double-barreled question, which is terrible to do that. Now, is termination a remedy? No, says Harley. I agree. So they're fundamentally different animals, really. So rescission is, generally speaking, a remedy. Sometimes, I say generally speaking, almost always, technically it is a remedy, but occasionally you'll see it used in a sense that is more like termination. But rescission is an equitable remedy, and it's essentially where the court upholds the party terminating the transaction's ability to do so. And a valid rescission can be used as a defence against specific performance. Do we know what specific performance is? Yes? All right, so it's an equitable remedy asking the court to essentially enforce a contract. So a valid rescission can be used as a defence to a specific performance action. So rescission is the right to repudiate or rescind, if you like, the contract that is voidable because of something that affected the consent of the party. Mistake is a good example that we're dealing with. Misrepresentation is a good example as well. So rescission is the ability to terminate a contract, and that's upheld in the court of equity or by the court exercising equitable jurisdiction. Now, termination is different because termination simply represents the point at which the contract comes to an end. Can anyone think of different ways that a contract might come to an end, that a contract might be terminated? Breach, says Harley. Potentially. Anyone else? Misrepresentation, says Jessica. Maybe. Condition, says Tanya. Maybe. Not the answers that I'm looking for, not the emphasis that I want you to understand. We're close. Death, maybe. Good guess though. You'd think that death would do it, but not always, because some contracts actually endure for the benefit of or detriment of the estate. Unequitable, Close, maybe. So what's termination? So termination, grossly unjust, maybe. So termination represents the point where the contract has come to an end. I guess the question that I'm asking is, what would cause a contract to come to an end? Well, one is that the contract is performed. So if you are tasked with the job of concreting a driveway, once you've concreted the driveway, the contract has ended. So the contract is terminated. Now, there are some rights and remedies that endure beyond the end of a contract, but that's, I guess, one example. If we're looking at the definition of termination being the contract has come to an end, well, performing the contract is one example. Another is through the agreement of the parties. The parties might say, look, you haven't quite finished, but look, I'll pay you the money anyway because it's near enough. I'm happy with it. So that's if you like, a waiver or a release. Or it might be that it's discharged as a result of some action where a party has taken action in response to, let's say, a breach or something else. The point that I'll make is this. I will encourage you to provide for yourself a little dictionary of these key terms that seem to crop up often. And apart from having a dictionary that works for you, I want you to work this into your flowchart or your checklist or your toolkit, whatever it is that you're using to assist you in answering problems, so that when you see a word, you can cross-reference it to your definition. But I then want you to go further, and I want you to identify legislation that's relevant to the term that you're defining, and I want you to identify one key case with a quote that's relevant to that as well. And it's not just rescission and termination. They're the ones that I'm using now as an example, but I would like you to use that for other things as well. Now, termination of a contract at common law is available to a party essentially as a remedy. I said it's not a remedy per se, but it's a process where one party who's aggrieved is able to declare or make a statement that they're terminating the contract as opposed to affirming it. So the act of termination is a process, and it's usually a choice. It's either I'm affirming the contract, going ahead with it, or I'm terminating the contract. I'm saying, no, we're not proceeding. And here's where we get into some interesting areas from a legal perspective. Now, does anyone remember what we mean by essential terms and non-essential terms of a contract? Anyone willing to let us know what that means? Essential terms, non-essential terms? All right, so essential terms, if you like, are non-essential can be removed. Jay's got the idea, conditions and warranties. Yes, that's pretty much what I'm looking for. So an essential term, generally speaking, is a condition. And there was an answer, I think, was it Gareth, I think, that said condition previously. But condition. And if a party breaches an essential term, then the rights available to that party are likely to be different to the rights associated with a breach of a non-essential term or a warranty. Generally speaking, if a party committed a breach of a condition or an essential term, it might have given rise to the other party to terminate the contract. That's at common law. But if a party commits a breach of a non-essential term, it might still give rise for that party to terminate the contract at common law. I'm just going to take a moment to ask if you could find for me the leading authority, High Court case for that proposition. I'll just pause for a couple of minutes. No one's found it yet? Compare to. So have a look. This is a really useful case dealing with that distinction. The case that I had in mind is compare to. I'll give to provided it's KOOMPAHTOO, Local Aboriginal Land Council against Sandpine, Pty Ltd, 2007 233 CLR 115. Put that into your toolkit and try to work out how it might be used, because it's a useful case to cite in a lot of these contract law questions. Now, an affected party doesn't have an obligation to accept a repudiation by the other side and terminate the contract. They can if they wish. I've just introduced a new word, repudiation. What does that mean? What do we mean by the word repudiation? So we're getting all these different words that sound a little the same, but we need to really understand the difference. Go back on? Yes? Yep. So if you repudiate a contract, so Jay says go back on, I think that's about right. I mean, if someone is contracted to concrete a driveway and then chooses not to do it, that's an act of repudiation, isn't it? What can the other party do about it? Well, they could affirm the contract, seek specific performance, or they might terminate the contract, but by accepting the repudiation, if you like, and acting upon it. So they might rescind the contract. So rescission's equitable. It's available where the contract is void or voidable, and the idea is to restore people to the original position. So a party may have, so how do you accept the repudiation? If someone repudiates, then you can still affirm the contract. So a good word to think of instead of acceptance is affirmation. And that's probably one of the key words. And a good example of this too is for those of you doing conveyancing, or if you've bought and sold real estate, and if you have access to a standard condition of a contract, the standard conditions of a contract, you'll see that particularly for the buyer and indeed for the seller, there are specific statements made about the party's ability to either affirm or terminate the contract as an election. And that can be for a whole range of different conditions that are breached under the terms of the contract or even warranty. Another thing that you need to be aware of is the effect of rescission. And generally, if a contract is rescinded ab initio, it means we go back to the original position. Now, do we know what we mean by that Latin term ab initio? It means as at the beginning. So you'll need to understand how that can work in. Void ab initio means, for example, if there's a misrepresentation has taken place from the beginning, says Marissa. Yes, I like that. Put the parties in the position they were in before the contract was formed, says Jessica. Absolutely, I like that. So that's the idea, to put the parties back into their original position. One of the consequences of that is that the innocent third party may suffer as a result. What do I mean by an innocent third party suffering as a result of a contract being declared void ab initio? A lot of Latin words and long words here. Can anyone give me an example? A rogue, yes. Goods sold on, says Harley. Yes, I think that's right. So it makes it very difficult. And it follows on from the Latin term non est factum. No, sorry, NEMO-DAT, the NEMO-DAT principle. So it may not be possible to return the parties to their original position because something has happened beyond that. So generally speaking, being an equitable jurisdiction, courts won't necessarily take parties back to their original position if it's impossible to do so. Someone says as close to the original position as possible. And if a third party owns the rights to the contract, then courts are reluctant to declare a contract void ab initio. But again, there's still that Latin term NEMO-DAT rule, which provides that it can create some difficulties for third parties. So one of the key things to consider in your flowchart is this issue of whether there has been a breach or there's been some vitiating effect, and what has the other side done about it, if at all? And if the other side did nothing, is there a problem potentially with latches, with delay, latches being LACHES? And then there's the further question of, well, what can you do about it? Which may mean considering whether it's an essential condition, an essential term, or a non-essential term. So you can see that the whole thing starts to splinter, doesn't it? Flowchart style. And the idea is to have this in your mind so that when you're presented with a problem and it's not made clear to you what each of the material facts are, let alone how they fit into a flowchart, at least you've got a chance of answering the problem by having some of your answer pre-populated, is really what I'm getting to. So that if you decide it's going to follow this route, you've already pre-populated that flowchart with the correct term, a definition for the term, the legislation that might relate to the term, case law, and maybe a quote. So that if you follow that route, you can then populate your answer and you've got a slab of material of high quality already written. You can do that for the exam. So the exam at the end of the year requires you to write. It requires you to answer a question. Why not, in part, have your answer written before you walk into the exam? Then you can just rewrite your notes, can't you? That's the sort of level of preparation that I'm keen for you to advance now before we go too much further. Now, apart from having the contract declared void or particularly void ab initio, damages is a traditional form of remedy, and it's available particularly at common law, but it's also available through equity. And some damages are available only where the conduct is a tort, such as fraudulent or fraudulent or negligent misrepresentation. In Queensland, generally, you can't obtain damages for innocent misrepresentation. And sometimes damages are available in addition to rescission. So it may be that your remedy is for rescission or damages or both. So again, when you're looking at your flowchart, you need to expand on this and work out to some degree where these remedies are available and how they might fit in to your answer to the problem. So when it comes to misrepresentation and damages, the first thing you need to do is prove the misrepresentation. We know that, don't we? But what else would you need to show in terms of misrepresentation before you could make a successful claim to damages? In other words, the misrepresentation alone is not enough, is it? What else do we need to show? I guess we're really talking about the elements of misrepresentation here. Harley says intent, yes. Gareth says duty. Jay says reliance and inducement. Yes. Any others? I think we're getting close, aren't we? Samara says the other party. Oh, I missed yours, Samara. Marissa says harm from failure. Right, so some good answers there. Made before contract, says Tanya. Yes, Jessica?
Before or at the time of the contract formation?
Yes, yes, that's a good point. And sometimes that's a little trick that examiners put in to a question in relation to this topic. So there must be an ability to show that the party who made the representation intended the other side to act upon that representation. So there was one answer there, intent, which is true. Now, following on from the intent to have this other party act on the misrepresentation is a requirement to show that they actually did so. In other words, it actually led to something. If nobody acted, then the misrepresentation means nothing, does it? And there must be harm. In other words, you can't claim damages unless there's some harm. So as a result of the misrepresentation, there's been some harm. You don't need compensation to restore a plaintiff to their original position, which is a rescission, but for damages, you do need to establish the harm. All right, I'm going to ask you to look at some legislation now. We don't do a lot of legislation work in contract until we get to the ACL, but the Civil Liability Act 2003, Queensland, if you've got access to legislation, have a look for that now. If you're watching this recorded session, please access the material. I'd like you to look at Section 5, which deals with the issue of civil liability excluded from the Act, and Section 4, which deals with the application of the Act. Have we found it yet? The Civil Liability Act 2003. Now, Section 4 says, subject to Section 5, this Act applies to any civil claim for damages for harm. So you'll need to look at what we mean by the term harm. The Act does not apply in relation to deciding liability or awards for damages for personal injuries if the harm does not result from a breach of duty in some areas. Now, the reason I'm suggesting that is that sometimes it gets a bit tricky to distinguish between contract and tort. You know, we've already been talking about negligent and fraudulent tonight. I've also, did I mention defamation? No, I don't think I did, but it gets to become a grey area. So even though the Civil Liability Act doesn't directly relate to contract law, and you're probably wondering why I'm talking about it in the context of contract, I want you to be aware that this other main area that relates to the issue of damages that goes very close to, in some instances, contract law. So just be aware of it and be prepared to deal with that issue. Now, there's a case that I want to bring to your attention, which is Jones and Dumbrell. It's a Victorian case from 1981. And it was to do with the manufacture of children's toys. I think it's in the notes. Jones was one of the company founders, asked by someone to buy his share. Dumbrell said yes, but on the basis that it was going to remain as a family company. So it was sold at favourable terms. Now, by the time the contract was formed, the purchaser had in fact formed the intention of reselling the company at a profit, which is what happened. And the question is, was there a misrepresentation? Dumbrell made a statement of fact which he knew to be false. So if there was a misrepresentation, it was fraudulent, but there are three other elements that need to be considered. First is, when you're applying those three areas that we discussed just a moment ago, did Dumbrell intend Jones to act on the representation, which was false? Answer is yes. Second, did in fact Jones act on that representation? Well, on the evidence, yes. And number three, was there harm? And again, yes, because the property, the business was sold at a lower price. So in that instance, we have three claims, or we have a claim that was successful for fraudulent misrepresentation. But going back to the Civil Liability Act, doesn't that look like something that was contained in Section 4? Because Section 4 says the Act applies to any civil claim for damages for harm. So I hope that you can see what I'm trying to achieve here, and that is just to carefully broaden your horizons just a bit. And one of the reasons you need to be careful about this is that the question that you have before you may actually not relate so much to contract law as to torts law or vice versa. From that, I can move on. Any questions so far? All good? All right. Now, of course, the important aspect really of contract law in the context of consumer material is the Australian consumer law. Can anyone tell me how they might find the ACL, as we'll often abbreviate it in legislation? Where would I find the ACL? We did this last week, so it's only a refresher. See who's first in. Where do I find the ACL? Schedule 2 of the Consumer and Competition Act, says Tanya. Thank you very much, Tanya. Very good. Schedule 2, says Marissa. So that's Commonwealth, correct? Yes. Are we happy that's Commonwealth? And can we find the ACL elsewhere in state legislation? That's a yes. I can see Marissa's nodding. Yep, we're on to that. And Tanya says, yes, that's true. All right. And we know where to find. What's the legislation in Queensland? We did this last week. So first in on the buzzers. Not quite, Natalie, not the answer I'm looking for. Peter, yes, Fair Trading Act. Peter was quickest on the mark on that one. You were just a little bit too quick, I think, Marissa. So the statutory scheme is very important. Now, when you're looking at, say, let's have a look at the Commonwealth legislation. The basis that it was enacted is a little tricky because the Commonwealth had to rely on specific powers conferred upon it. Section 51, subsection 20, XX, provides power to make laws in relation to corporations. So when we're talking about the ACL at a Commonwealth level, are we really talking about corporations in the context of, let's say, misleading and deceptive conduct? Is that a fair statement that we're really talking about corporations? Aha, very good, Gary. You worked out the trick. Section 6 provides that natural persons can also be affected. This is where it gets a bit tricky. In reality, what you probably would do is plead in a number of ways. And we talked about pleading, didn't we, in week 1 or week 2? Pleading is the form of document that sets out your case, not the evidence, but just sets out the argument, the legal argument, essentially. based on some of the facts as you allege them to be. So you might plead that there's been a breach of the Australian consumer law at a Commonwealth level or at a state level by referring to the specific legislation in the sections, or you might plead and alternatively, you might plead, or in addition, common law breach as well. So when we're looking at the state legislation, we need to look at the Fair Trading Act, 1989. We know that. Key sections, I think, have a look at sections 3, 4A, 4B, and 16. If you've got access to the Fair Trading Act now, do that. Has anyone set up bookmarks for Contract B? Yes, Natalie? Good. So I would think that you'd set up a folder. It might be contract law, it might be consumer law, something along those lines, and you've bookmarked the legislation so that you can get to it very quickly. Not just that, but articles or other material. So being well organised will help you when it comes to prepare for the examination and also complete your assessment work. All right, so Section 3 of the Fair Trading Act provides for the objective of the Act, which is to improve consumer well-being through consumer empowerment, protection, fostering effective competition and enabling confidence of the consumers. 4B talks about the application of the Act. So it's always important to have a look at the application provision. And 4A says that the Act applies to persons carrying on business in Queensland or bodies corporate or persons ordinarily resident in Queensland or otherwise connected to Queensland. So there's got to be that jurisdictional aspect to Queensland. What that means is that it's quite possible that legislation, the ACL Commonwealth and the ACL state do apply in the same circumstances. But have a look at Section 4B, which says that a reference to the Act may be taken to include a reference to the Australian Consumer Law Queensland. And Section 16 specifically states that the ACL, as it is from time to time, applies as a law of Queensland in that jurisdiction and may be referred to as the ACL Queensland. All right. So, in your notes, there's the comment, which is true, that in reality, the primary argument that people use in advancing claims in relation to misrepresentation is pursuant to the ACL as misleading or deceptive conduct rather than necessarily a misrepresentation, which is more the common law position. Have a look at Section 20 of the Australian Consumer Law also. Section 18 is obviously very important, but Section 20 is also important, which deals with unconscionable conduct. And a person must not, in trade or commerce, engage in conduct that is unconscionable within the meaning of the unwritten law from time to time. So what's the basic principle? The basic principle is that if a business engages in conduct that misleads or deceives, was like to do that, then consumers or even other businesses can obtain a remedy. And even if you didn't intentionally go about wanting to mislead, if that was the effect, then it can still be misleading or deceptive conduct because we use the objective test. We talked about that last week. So, did the behaviour tend to lead the person into error is really what it's about. Okay, now it's all very well to say that these are the statutes, and for the moment we're talking about statutes, the statutes you can rely upon, but when it comes to damages, can anyone tell me if there is a specific provision in the Australian Consumer Law that provides for the remedy of damages? We're not talking common law damages now. We're calling statutory. We're talking about statutory damages. Where do you look? Jessica's very good. Section 237. There's another one as well that I've got in mind. 236 says Gary. Yes. So 236 and 237. If you haven't looked at those, please do so now. Make sure that you have them bookmarked. And Gary makes an interesting point. Just watch out for limitation periods. 6 years. Thanks, Gary. That's very important. So 236 of the Australian Consumer Law provides for the actions to be available for damages. And it's pretty broad because this is a very broad area of practice, isn't it? Misleading and deceptive conduct. It's very simple, minimal drafting, but with huge consequences. So if a person suffers loss or damage because of the conduct of another person, and the conduct contravened a provision of chapters 2 or 3, this is of the ACL, then the claimant may recover loss or damage against that person or any other person involved in the contravention. But again, as Gary points out, 6 years is the limitation period. The 6 years is relevant because it may be directly relevant to the question that's asked, but if there's no dates mentioned in the question, you say that there's a claim for damages available under statute, you're making an assumption that's within the 6 year period. So that's a critical assumption. Best if you say it in your answer. Now, of course, apart from damages, which is 236, the court can make such orders as it sees as appropriate, which is really section 237. And compensation orders can be made on behalf or by an injured person or by a regulator for engaging in a whole range of different matters. So have a look at section 237 in that regard. Now the section 237 talks about a range of orders that are available, but the orders that are available, where are they listed? Where would you find them? Two, 4, 3, says Marina. Jessica, Marina, just beat you. That's it. You're both spot on. So look at 236, then go to 237, then go to 243, which talks about the kinds of orders that can be made. And there's a wide range of orders. So when it comes to talking about remedies for misrepresentation, we've got these broad three-way distinction, don't we? We have those remedies available at common law, usually damages. Those remedies available by invoking equity, which might be rescission, for example, and those remedies that are available under the statute, which is really broadly wide-ranging. So if you're dealing with an answer to a problem around this area, odds are you'll need to address all of those. And when you do, if you're making assumptions, please ensure that you state those assumptions, if they're important ones. Any questions so far? I know I'm doing a lot of talking, but you're doing well. All right, so the Australian Consumer Law provides a lot of broad avenues for dealing with consumer protection. Section 29 deals with false and misleading representations about goods and services. So if you're going into the advertising industry, probably the first thing you'd want to do is look at Section 29 of the ACL. But it might be not just for advertisers, but for individuals or for companies that are in business. You know, a person in trade or commerce in relation to supply or possible supply of goods or services in connection of the promotion by any means of that supply is not allowed to make false or misleading representations. Is silence a false or misleading representation? At common law, it's not. Was that Feldhaus and Brindley? Was that the case? I think it was. But under the statute, it might be different. We're looking at an objective test. So keep that in mind. All right, so we're looking at the key points. So for the purposes of Section 18 of the ACL, physical actions or written words, oral words, and silence can all constitute conduct for the purposes of Section 18 of the ACL. Misrepresentation and misleading and deceptive conduct are essentially the same thing. It's just that misrepresentation is common law, misleading, deceptive conduct is the statutory phrase. Misrepresentation is the body of common law and equity built up to protect contracting parties from innocent, negligent, and fraudulent misrepresentation by the other, whereas misleading and deceptive conduct is essentially the statutory equivalent of that same behaviour. Please ensure that you have the right terminology when you're referring to common law or equitable remedies compared with statutory remedies. Misrepresentation entitles an innocent party to rescind the contract if the misrepresentation was fraudulent or negligent, and of course if the innocent party suffered harm as a result. And the innocent party may then also seek tortious damages. But the Australian consumer law provides a wide range of remedies, primarily compensation, but it goes well beyond that, and it's where a person or a corporation has engaged in misleading or deceptive conduct, but in the course of trade or commerce. Sometimes people forget that in the course of trade or commerce. And when people negotiate with each other, they're not at liberty to simply mislead each other in order to obtain an advantage. Assertive negotiations allowed, but outright misrepresentation will involve the court providing protection. So sometimes you need to make that distinction. Will equity also step in if there's been a contravention of a statutory provision? Good question, Jay. The answer is it might, but it depends on the circumstances. So if there's a breach of a statutory provision and it's fairly stated that that is a clear breach of the statute, then odds are you'll probably only be looking at the statutory remedies. But if the action could be properly categorised as either a breach of common law or equitable principles or statute, then you'd probably argue in the alternative or in addition to each other. I hope that answers the question. Okay, we've got a little bit of time left. As you could probably tell, we've been dealing with week 2 material tonight, and then we're in week 3. So at some stage or other, I'll need to catch up. But I just want to have a break from talking about contract for a moment and just talk a bit more generally. One of the things that you need to do is look after yourself as you're progressing through your studies. Part of that means managing your expectations. One of the things that you might have realised is that I certainly don't expect you to know all the law. And the reality is that no one does. I know it's meant as a compliment, but occasionally people will come up, certainly to me, and over the years, they'll engage in some sort of legal discussions relevant to them. And they might start the statement by saying, you know, as you know, Regulation 26 of the Marine Park Conservation Act, which is fictional, or regulations, says this, you know, to do with something. And I'd say, And now I just say, no, I don't know that. I did not know that, because you can't know everything. Now, the point that I'm trying to make is don't have too many high expectations of yourself. What you really need to do is understand the basic principles, have a great system that you've worked out that you can go to when the time is required, and then have really sharp research skills so that you can honestly say, no, I don't know the answer, but you can equally honestly say, but I think I can find this out because I've got a good system and I understand the way it works. So don't for a moment think that you've got to remember all of this, or you've got to have a clear understanding and knowledge at the time. Now, of course, what it means is that you've got to be able to identify the primary and the secondary sources of law. We know what they are, don't we? We've all done introduction to law, some of you with me. So primary sources. Okay, what are the primary sources of law? See who's quickest on the buzzer. Legislation, case law, common law. Yeah, so the two. So primary sources, legislation and case law, common law. Secondary sources, textbooks. When you're looking at legislation, don't forget your statutory interpretation days and make sure that you're aware of, for example, Section 15A(b) of the Acts Interpretation Act Common Law. So don't discard anything to do with statutory interpretation throughout your career as a student and then as a practitioner or in whatever sense that might be. It's always there. Statutory and many of you know that I have taken statutory interpretation, and I haven't put those courtroom presentations up, Gary, but I will do that soon. So just remember your statutory interpretation. Remember also the case law and the hierarchy that applies, so have a good understanding of that. Now, one thing that you might find is that I will ask you directly, what court would you expect to deal with this matter? If you're seeking a certain remedy, you've got to know what court. So if you're seeking damages, it's not likely that you'll go to, damages for misrepresentation. It's not likely that you would initiate your proceedings in, say, the Mental Health Review Tribunal. So it's got to be somewhere else, doesn't it? So quick on the buzzers. What's the maximum monetary jurisdiction for the Magistrates Court in Queensland? Who's got the answer for me? No, Jay, not really. Anyone? We're all Googling now, aren't we? 150K, says Peter. Yes, $150,000. We all know what the next question is. What's the monetary jurisdiction for the District Court in Queensland? $750,000, says Peter. Thank you. We know the next one. What's the monetary jurisdiction for the Supreme Court? Unlimited, says Peter. 3 out of 3 to Peter. No one can beat him on this topic. Trick question. What's the monetary jurisdiction for the Queensland Civil and Administrative Tribunal, aka QCAT? So that's a trick question. Unlimited, says Gareth. Yep, in most of its jurisdiction. Peter says depends on the case. Yes. So if it's a minor civil, so QCAT's an amalgam of, I think it's a 10th anniversary of QCAT, by the way. I think 39 tribunals. One of them was the Small Claims Tribunal. That was one of the 39. And the jurisdiction for that, which is under what's called the minor civil disputes jurisdiction of QCAT, is I think now $25,000. But for retail shop lease disputes, the jurisdictional limit for QCAT, which is flow on from the old Retail Shop Leases Tribunal, But for retail shop lease disputes, the jurisdictional limit is 750,000, but otherwise it's unlimited. Now, just another question. If you refer to a judge in court, you address a judge in court, what's the right term? If you're on your feet, because you need to do this, won't you? No. Gary's close. Ah, yes, now we're getting the right answers. Your Honour. So while you're in court addressing a judge, then the correct term is Your Honour. What about if you're in court and you're addressing a magistrate? What's the correct term? Not quite, no. You're in court, you're addressing a magistrate. What's the term in Queensland? Marissa's correct, Your Honour. Oh, and Gareth gave the extended version, which is correct. It was previously Your Worship, but it's now Your Honour. And when that change occurred, those of you that were in court often would make a mistake. And I think at one stage we used to have like a penalty jar. You had to put in 20 cents or something if you got it wrong. Jay asked a good question. What about tribunals? What would you call a member of a tribunal hearing a case, typically? What's the correct address term? Gary's got it, member, that's right. Okay, so Your Honour or member, typically. In social settings, what would you call a judge? How would you address a judge in a social setting? Judge, that's it, Matthew, perfect. Perfectly permissible. Might be Chief Judge or Chief Justice, but otherwise judge is fine. Otherwise, for magistrates or members, usually just their, Mr. or Mrs. or whatever it is. Okay, we're just about, no, you wouldn't use, you would use their other name. You wouldn't say Judge Jones, you just say Judge. You could use Sir or Ma'am, but Judge is better if you're part of the legal system. For example, if you meet the Attorney General socially, then generally those within the legal fraternity would refer to the Attorney General as attorney. Same with judge. So it shows that you're part of the legal fraternity, which you all are now. All right. Same for tribunals. Privately, in court or in a tribunal, it would just be member rather than the full name. And yeah, it's all, Gareth says, just shows respect for the position. That's the idea. But respect, but also with a little degree of informality to reflect the fact that we're all part of a profession. So I'm sorry for that diversion. Next week we'll start with estoppel, and we will talk about how estoppel is different from misrepresentation, how it's different from mistake, but how it can sometimes be confused between the two, or these concepts are different. We'll also talk about different types of estoppel, and they're all generally under this banner of estoppel, but some can relate to unconscionability, which is conduct, or promissory estoppel, issue estoppel, record estoppel. And estoppel, of course, generally simply means that you can't go back on something. Having said something or done something and others have acted on that basis, then you can't go back and change. So just a final quick quiz before we close for tonight. In Australia, what would you regard as the leading case on estoppel? Any thoughts? I'm not suggesting there's necessarily a right answer. what do you think is the leading case? Waltons, High Tree, Pinnells. We're getting a few different votes. High Trees. Waltons getting a few more votes now. I'll go with Waltons, was the one I had in mind. So Walton Stores and Mars, Walton Stores and Mar is I think the key case. But I'd like you to do your reading. You should have probably done that this week already. So you'll best understand the progression of cases, the historical development from Hughes, or Pinnells really, but from Hughes to Birmingham to High Trees House, and then to Walton Stores and Mar. Understand that progression and how it works in practice. All right, thank you very much for your patience. Any questions in relation to what we've covered tonight, what we're going to cover next week? Assessments, anyone else? Anything else? No, all good?
Just that those Progo videos, if we could get those Progo videos up, please, mate.
Will do.
Thanks, mate.
All right, nothing else? All right. Thank you very much, and we'll see you soon. Okay, bye then.